May a public officer be validly sued in his or her private capacity for acts done in connection with the discharge of the functions of his or her office? The rule in this jurisdiction is that a public officer may be validly sued in his or her private capacity for acts done in the course of the performance of the functions of the office, where said public officer 1. Acted with malice, bad faith, or negligence, or 2. Where the public officer violated a constitutional right of the plaintiff. Further, when a general law conflicts with a special law, the latter prevails. Article 32 of the Civil Code, though part of a general law, is a special provision that holds public officers civilly liable for violating constitutional rights. This provision creates a distinct cause of action in the nature of tort, separate from the general rule on civil liability under the Administrative Code. Thus, claims for damages based on constitutional violations must be adjudicated under Article 32 of the Civil Code, rather than the broader provisions of the Administrative Code. The pivotal issue in this case is whether a corporation, which is built through its agents, water paths, water conductors, and contrivances within its land, thereby causing inundation and damage to an adjacent land, can be held civilly liable for damages under Articles 2176 and 2177 of the Civil Code on quasi-delicts, such that the resulting civil case can proceed independently of the criminal case. Property ownership has limits. Under Article 431 of the Civil Code, an owner cannot use their property in a way that harms others. Adjoining landowners must act reasonably to avoid infringing on each other's rights. While owners can build structures, they must ensure these are safe and can withstand natural forces. If a structure causes harm, the affected party may seek compensation for damages under Article 2176 of the Civil Code. For damages suffered by a third party, may an action based on quasi-delict prosper against a rent-a-car company and, consequently, its insurer for fault or negligence of the car lessee in driving the rented vehicle? For a claim based on quasi-delict under Article 2176 of the Civil Code to prosper, the plaintiff must establish a. Damage suffered, b. Fault or negligence of the defendant, and c. A causal connection between the defendant's negligence and the damage incurred. The mere ownership of a vehicle does not automatically render the owner liable for the negligence of its driver. Under Article 2180, liability arises from a presumption of negligence in failing to supervise subordinates, which requires an employer-employee relationship. A car rental company that merely leases a vehicle, without control over the lessee's actions, is not vicariously liable for the latter's negligence. The core issue to be resolved is whether the complaint, a civil suit filed by the plaintiff, is based on quasi-delict or malicious prosecution. A civil action for damages arising from the negligent filing of criminal charges without proper verification of the accused's identity may be anchored on quasi-delict under Article 2176 of the Civil Code rather than malicious prosecution. The nature of an action is determined by the allegations in the complaint and the relief sought, not merely by the labels used by the plaintiff. When a party claims damages due to the negligent acts of another, without alleging bad faith, the action falls under tort law rather than a willful or malicious act. Is the present civil action for damages barred by the acquittal of Reginald in the criminal case wherein the action for civil liability was not reserved? And can Article 2180 of the Civil Code, the parental liability for damages caused by minor children, be applied against Marvin Hill, despite Reginald's emancipation by marriage? The acquittal of an accused in a criminal case does not automatically bar a separate civil action for damages based on quasi-delict arising from the same act. The civil action may proceed independently, as the standards of proof and the purposes of criminal and civil liability are distinct. In cases of quasi-delict, the focus is on the damage caused and the fault or negligence of the defendant, rather than the criminal intent. Under Article 2180 of the Civil Code, parents are jointly and solidarily liable for damages caused by their minor children who live with them. The obligation to supervise and control their children persists despite the child's marriage if the child remains dependent on the parents for subsistence. Emancipation by marriage does not grant a minor full legal capacity to act independently, as seen in Article 399, which still requires parental assistance in judicial matters. Consequently, a minor's marriage does not absolve the parents of their duty to prevent their child from causing harm to third persons.